so much. I'd like to welcome Marjorie Cohn to the stage. Marjorie is a professor emerita at Thomas Jefferson School of Law, a former national president of the National Lawyers Guild, a criminal defense attorney who is a legal scholar who writes books and articles and lectures throughout the world about human rights, foreign policy, and the conflicts between the two. She is the author of The United States of Torture, Cameras in the Courtroom, and Drones and Targeted Killings, among other books. Her columns appear on Truthout, HuffPost, Salon, Truthdig, and other online publications. Professor Cohn will be addressing the legality of the U.S. seeking to extradite Julian Assange back to the U.S. under the extradition treaty with England.
Thank you, and I'm so pleased to be here for this important event and with my colleagues on the panel, of whom I am in awe, so thank you. Julian Assange is facing an extradition hearing on February the 25th, and the US and the UK have an extradition treaty that was concluded in 2003. So the United States is trying to convince the UK to extradite Assange to the United States for trial. Under this extradition treaty, extradition shall not be granted if the offense for which the extradition is requested is a political offense. And extradition shall not be granted if the competent authority of the UK determines that the request was politically motivated. In the United States, the executive branch, and of course you know who that is the competent authority for purposes of this act. And I use competent only because it's the word that's used in the treaty. Now, like most extradition treaties, the US-UK extradition treaty excludes political offenses. There's no clear definition of that term, but it routinely covers crimes like treason, espionage, and sedition, as well as offenses that are directed against the power of the state in some manner. Julian Assange is wanted in the United States primarily for embarrassing the Department of Defense and the State Department by publishing true information that was obtained from Chelsea Manning, the whistleblower, which makes the charges political in nature as opposed to criminal. Edward Snowden, who is currently living under a grant of asylum in Russia, could have been extradited to the United States if Russia or Hong Kong, where he left, or Ecuador, which he was on his way to Ecuador, had wanted to extradite him. And had he not been granted asylum in Russia. He's another very prominent whistleblower who blew the whistle on massive surveillance by the National Security Agency collecting our metadata, and he is wanted, of course, in the United States at the present time. The US and Russia do not have an extradition treaty, although under the Obama administration and other administrations, people have been extradited from Russia to the United States. And like Assange, Snowden has been charged under the Espionage Act, classic political acts for which they stand charged. Now there are some other important instruments that you should be aware of. The Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, which is part of U.S. law under the Supremacy Clause of the Constitution, treaty shall be the supreme law of the land, includes a provision called non-refoulement, and that means it forbids the extradition of a person to a country where there are substantial grounds to believe he would be in danger of being tortured. Now, given the fact that Chelsea Manning was tortured by being kept in solitary confinement for 9 months, there is a good chance that Assange could also be tortured. And I'm going to talk a little bit later about the torture of Julian Assange in prison in the UK. But there is a reasonable suspicion that he could face torture if he were extradited to the United States. Also, a country has an obligation to refuse extradition when it would violate fundamental rights. And the right to be free from torture and cruel treatment is a fundamental right. Finally, the Johannesburg Principles of National Security, Freedom of Expression, and Access to Information, which were enshrined in 1996, provide no person may be punished on national security grounds for disclosure of information in the public interest in knowing the information outweighs the harm from the disclosure. Now, after the hearing, the extradition hearing, if that goes against Julian Assange, it could be appealed through the British courts and even to the European Court of Human Rights. And despite Britain's Brexit vote, the UK government has agreed to remain under that court's jurisdiction, at least for the time being. Even if Julian Assange is brought to the United States, he could try making many of the same arguments in US courts about it being a political offense, etc. However, he would not likely find a sympathetic reception because he has been so vilified in the United States. Thank you.